Good morning, viewers. Welcome to this law lecture series. Today's topic is Substantive Law and Procedural Law in English. Very soon you will have the Hindi version of this lecture also. Look, here is the synopsis of the topic. First, Substantive Law, and the second, Procedural Law. Now, what is Substantive Law? Three basic points about substantive law. First, substantive law determines rights, liabilities, and disabilities of the parties. Substantive law determines the rights, liabilities, and disabilities of the parties. Second, a substantive law may be civil or it may be criminal also. A substantive law may be civil or criminal. And third, no act or code is purely substantive or purely procedural. So these are the three very basic elements, very basic points about substantive law. I am repeating it once again. First, substantive law determines the rights, liabilities, and disabilities of the parties. Second, the substantive law may be civil or it may be criminal. And the third point is that no act, no code or statute is 100% substantive or 100% procedural. Some provisions may be procedural in a substantive law. Some provisions may be substantive in a procedural law. So no act, statute or code is 100% substantive or 100% procedural. Now let us examine. Substantive law determines rights, liabilities, and disabilities of the parties. We will understand it with the help of some examples. I say, I am the owner of this property. I say that I am the owner of this property. My opponent says, no, you are not the owner of this property. You don't have ownership. Now the question of ownership is there. Right to ownership is there. How the question of right to ownership will be decided? It will be decided by substantive law. Law as to inheritance, law as to wills, law as to transfer of property. These are the substantive laws which will determine whether I have ownership over this property or I don't have ownership over this property. Liability. I say that you are a murderer, and so you are liable to be punished under section 302 IPC. And you say, no, I am innocent. I have not committed any murder. Now, whether you are liable for murder or not, that is to be decided by section 299 IPC, section 300 IPC, and provisions like general exceptions to the IPC. IPC is a substantive law. It will determine whether you are liable or not liable for murder. Third, I say to you that you are incompetent to contract. You are suffering from a disability. You are a minor, or you are a person of unsound mind, or that you are a disqualified person. So you are disabled from entering into a contract. You say, no, I am not minor, I am not a person of unsound mind, and I am not a person disqualified by law from contracting. I am a competent person. So whether you are competent or not competent, you are able or disabled, that will be decided by the Indian Contract Act, a substantive law. So substantive law determines rights, liabilities and disabilities of the parties. Now, second, substantive law may be civil or it may be criminal. See here, Indian Contract Act, the Transfer of Property Act, the personal laws and the tax laws. These are all civil substantive laws. Civil substantive laws. And here the IPC and the NDPS Act, the Indian Penal Code, and the Narcotic Drugs and Psychotropic Substances Act. These are substantive criminal laws. So a substantive law may be civil or it may be criminal. Substantive law may be civil or criminal. TPA, Indian Contract Act, personal laws and taxation laws are the examples of substantive civil laws. IPC and NDPS Act, these are the examples of substantive criminal law. Now, third point. No act or a code or a statute is purely substantive or purely procedural. Some of the provisions in a substantive law may be procedural in nature. Likewise, some of the provisions in a procedural law may be of substantive character. So no act, statute or code can be 100% substantive or 100% procedural. Now see the example. 82 IPC. IPC is a substantive law, substantive criminal law. But section 82 of the IPC is procedural in nature. It provides for conclusive presumption of incompetence of a child under 7. If the accused is a child under 7 years of age, law conclusively presumes, section 82 IPC conclusively presumes that he is doli incapax, that is, he is incapable of committing an offense. This is a conclusive presumption, and you know that presumption relates to evidence and evidence relates to procedure. So section 82 IPC is procedural in nature. Likewise, section 115 Indian Evidence Act. Indian Evidence Act is procedural law, but its section 115 have some overtone of substantive law. Suppose I say that I am the owner of this pen. I am the owner of this pen. Do you want to purchase it? If you want to purchase it, pay me 20 rupees and I will give it to you. I am not the owner of this pen, but I am falsely misrepresenting, intentionally and knowingly misrepresenting that I am the owner and I have a right to sell. In fact, I am not the owner. In fact, I have no right to sell. I have no right to transfer. But I falsely, intentionally and knowingly making a misrepresentation that I am owner. And you act upon that misrepresentation, taking me to be the owner of this. You pay rupees 20, you paid rupees 20 to me, and I delivered this pen to you. Subsequently, I say that no, I was not the owner at that time when I sold it to him. At that time, I was not the owner, so I had no right to sell. Now you can say, no, I will not hand over this pen back to you because you made a misrepresentation. You are stopped from saying that you had no right to sell. So here my right will go. I cannot claim back this pen from you. So law as to estoppel in a certain way affects a person's right. So it is substantive in nature. Though it is given in the Indian Evidence Act, which is a procedural law, but in its nature, it is substantive because it affects my right. It affects the right of the person making false misrepresentation. He cannot claim back what he has sold. Now see the procedural law. Procedural law is also known as adjective law. Procedural law and adjective law are synonymous terms. Procedural law prescribes procedure. It prescribes machinery. It affords practice. So a procedural law or an adjective law affords machinery, affords procedure, affords practice for enforcement of substantive law. Second, what is the jurisprudential basis of a procedural law? Ubi jus, ibi remedium. Where there is a right, there is a remedy. Where there is a right, there is a remedy. Ubi jus, ibi remedium. If you have a right, that right has to be enforced. How? Through procedural law. So procedural law or adjective law prescribes procedure. It prescribes machinery and practice for enforcement of fundamental right. No fundamental right or legal right or substantive right can be enjoyed without a procedural law. Nature of procedural law. What is the nature of procedural law? See, first point. It is an adjunct. It is an adjunct or accessory to the substantive law. This is substantive law and this is adjunct. Attached things, linked things. So procedural law is an adjunct or it is an accessory to substantive law. If you have a car, you require a road. How that car will move if there is no road? So for substantive law to be operative and to come into effect, a procedural law is necessarily required. So it is said that a procedural law is a necessary adjunct or it is an accessory to the substantive law. Procedural law is a servant and not a tyrant. What does it mean? Procedural law is a servant and not a tyrant. You have to know, you have to remember that procedural law provides mechanism. It acts like a servant. It affords a platform on which substantive law is to run. Procedural law is a servant and it is not a tyrant. Procedural law cannot give you what is not given by substantive law. Procedural law cannot give you anything what is not given by substantive law. And the converse is also true. Procedural law cannot take away from you something that has been given by substantive law. So whatever is given by substantive law cannot be taken away by procedural law. And whatever is not given by substantive law cannot be given by procedural law. Procedural law is only a necessary adjunct to the substantive law. It is a servant, it is not a tyrant. Now, principles of interpretation relating to procedural law. While interpreting a procedural law, these rules are to be taken into consideration. First, rule of procedure. Any rule of procedure is to be interpreted liberally. It is to be construed liberally. Any rule of procedure is to be construed liberally, not strictly. A hyper-technical view is to be avoided. One has to be flexible. One has to be flexible and liberal. A hyper-technical view is not to be taken in the interpretation of a rule of procedure. First, a rule of procedure is to be interpreted liberally. Second, a hyper-technical view, over-technical view is to be avoided. Third, relief cannot be refused on these grounds. Suppose you have a right. Suppose you have a right, then you must be allowed to enjoy that right. Some procedural lapses are there. Suppose there is some mistake, there is some inadvertence, there is some negligence, or there is some infraction or breach of rule of procedure. Well, that is objectionable. But merely on the grounds of mistake, inadvertence, negligence, infraction or breach of any rule of procedure, you will not be denied, you will not be deprived of your right. So these are lapses. These are lapses, but not such a serious lapse that a person can be denied his right. No. We have to be liberal and we have to avoid hyper-technical view in the interpretation of rules of procedure. See here, this is the leading case. Jai Ram Manohar versus National Building Materials Supply Company, 1969 Supreme Court. This is a leading case on how to interpret a rule of procedure. How to interpret a rule of procedure. Jai Ram Manohar versus National Building Materials Supply Company's case. First, in interpreting a procedural law, one has to be liberal. A hyper-technical view is to be avoided. Mere mistake, mere inadvertence, mere negligence, or a little infraction of a rule of procedure is not a valid ground to deny a person, to deprive a person of his right. This is the leading case covering all these points. Interpretation of rules of procedure, very well elaborated by Honorable Supreme Court in this case. Thank you very much.